Yes, sir.
Yes. So today we are having a look at the Real Estate Regulation Act 2016 and certain provisions of the Act. Now, before we proceed with the Act, let us see the history so that we will understand the purpose and object of the Act and what was achieved by introducing this Act. Now, if we see in particularly Maharashtra, there was Maharashtra Ownership of Flats Act 1963. This act in certain areas such as providing the adjudicating mechanism, this act failed, and therefore Maharashtra wanted to introduce its own Real Estate Regulation Act 2012. Now, as you are aware that the laws relating to property are falling within the Schedule 7 concurrent list of the Constitution, and therefore approval of the President was required. When this law was sent for approval, the government thought that it would be appropriate that a central law is introduced in this area, and accordingly, Real Estate Regulation and Development Act 2016 was introduced. Now, the objects of the Act, mainly, if we see, are to regulate and promote the real estate sector and to bring transparency in the entire process of real estate sector. And while bringing transparency, protect interest of consumers in the real estate sector. And mainly, as I stated, where MOFA failed, to establish an adjudicating mechanism for speedy dispute redressal and to establish appellate tribunal to hear appeals from the decisions of the authority. Now, therefore, if we see, the intention of the act is to bring transparency. Therefore, what this act did basically is it introduced a provision in the act where it was made mandatory for the builder to disclose all the relevant aspects regarding his project on a website to be established by particular state, every state rather, and it was to be disclosed on the website. All the necessary documents are to be uploaded on the website, and that will give access to the prospective flat purchaser and bring transparency. Similarly, this act was established for the purposes of speedy dispute redressal forum. Now we have to understand one thing. I have been told that all of you are preparing for the examination which is to be held for the purposes of appointing authorities. Now, it is not that there was no remedy available prior to this act was introduced. But what happened is the remedies which were available failed to do justice as they were taking a lot of time. So, for instance, if you have to file a civil suit under MOFA, it would take years together to get justice, or rather you can say decades sometimes in certain cases. Now, this act intended to deliver justice speedily. And for that purposes, for the first time, under this act, a real estate regulatory authority was introduced. So all the complaints which are now between the allottees and the promoter would go to this real estate regulatory authority, which is established under Section 20 of the Act. And the mechanism which is provided for the speedy disposal is that the complaint is to be disposed of, or can be rather disposed of, within 6 months from the date of filing, because it goes, or rather it bypasses various provisions of CPC and it provides inbuilt mechanism for disposal of the complaints. Similarly, To avoid delays in appeals, there is an appellate tribunal established under the Act, under Section 43 and 44 of the Act, whereby the appeals against the decisions of the regulatory authority are to be decided expeditiously. So, as I said, two objects. One is to expedite the disputes between the consumer and the builder, and second, to bring transparency. Now we'll come on transparency. The Act said, or rather provides, that, as I stated, certain documents are to be uploaded by the promoter, which are more particularly mentioned in Section 4 of the Act. Now the Act contemplates that Section 3 of the Act provides that no marketing or advertisement or sale of any apartment, land, or building shall be done without the same being first registered with the regulatory authority. Now, what is registration of the real estate regulatory authority? As I explained to you, the Act mandates that every state will have its own website regarding this particular Act, where the builder will have to first register his project. Now, while registration of his project, the builder will have to upload various documents which are mandated under Section 4 of the Act. Now, what are these documents? So basically, the Act mandates that builder must upload the layout, thereafter the building plans, thereafter the apartment plan, the title to the project. Then the builder is required to give date of possession, that when he will complete the project. He will have to disclose the amenities which are there along with the project. Now, for the first time, under this Act, there are three requirements which were introduced, are the three certificates. Three certificates which are mandated under this Act are the certificate to be issued by a chartered accountant, certificate to be issued by the architect, and certificate to be issued by the engineer regarding stepwise completion of the project. Now, what Section 4 mandated also for the first time is that whatever money builder receives from the sale, he has to deposit that money, which is in a bank account disclosed to the authority. And importantly, he can use 70% of the said money as per the progress of the project, as and when these three certificates which I mentioned of chartered accountant, engineer, and architect are uploaded and are submitted to the bank. It is only when the completion of work is certified that the builder can withdraw money as contemplated under the Act. Now, having said that, the ongoing situation was taken into consideration where the projects were going on for years together, and either some of the projects were abandoned, some of the projects were pending completion, some projects were stuck because of finance or litigation. So this aspect was taken into consideration while introducing the Act. And the Act said that this Act will apply to every single project which had not received occupation certificate on or before 31st July 2017 when this Act came into force. So every project which was incomplete on the day when this Act was introduced was required to be registered under the Act. Now, why it was required to be registered under the Act is, as I stated, one, to bring transparency, and secondly, from coming into force this particular Act, the litigation or the disputes between the flat purchaser and the promoter will have to be adjudicated by the real estate authority. And to adjudicate those projects or to adjudicate those disputes, it was required that the project is registered with the authority so that the authority will have full control and knowledge and access to the documents regarding the project. Now, the Act considered a situation where the promoter may not complete the project or abandon the project or may not intend to complete the project. Now that is where the section 7 of the Act comes into picture. Section 7 of the Act empowers the authority that if the promoter fails to complete the project within the timeline prescribed by him or within the date of possession which was given by him on the website, then or he violates any of the terms and conditions of the approval given by the competent authority, or involves in any unfair practice or irregularity, then section 7 provides that in such circumstances, the authority was empowered to revoke the registration of the project. Now, revoke the registration of the project means automatically not only the authority will revoke the registration of the project, but the authority was further given powers to give in such directions as may be necessary for completion of the project. So section 7 says that one authority is now empowered to revoke the project. Section 8 of the Act says that where such a project is revoked, then what steps the authority or orders the authority can pass, including handing over of the project by taking over the same from the promoter who was doing the project, taking over of the project and handing over the project to the Association of Flat Purchasers. To the Association of Flat Purchasers. Now, we will have to see, I will come to the judgment of the Supreme Court later on. First, we will have a cursory look of the Act and then I will discuss the judgment which provides for similar mechanism. Now, say after this Act for the first time mandated registration of the real estate agents. So the way it created bar under section 3 for the promoters to sell, market, advertise the project. Section 9 was introduced in the Act, which said that no real estate agent shall facilitate the sale or purchase of the Act or facilitate the sale or purchase of the plot, apartment or the building as the case may be, without the same being registered, without he being registered with the authority. Now, that was done obviously with an intention that the Act intended to overall take care of the entire real estate industry, which included the real estate agent. We have to understand one thing, friends, that when this Act was being introduced, in India, the real estate sector was not organized. And when I say not organized, means there was no basic guidelines and requirements to control the promotion and completion of the real estate project. There was no Act which used to control or mandate certain directions. There were piecemeal acts where various directions were there. Registration of societies was there. Maharashtra Ownership of Flats Act was there. Maharashtra Apartment Ownership Act was there. But one consolidated act where under one umbrella all solutions will be provided was not there. And this was the main object of introduction of Real Estate Regulation Act 2016 to bring all the possible solutions under one act. Now, after, as I said, that the registration of the agent is required under the Act, the chapter 3 of the Act under section 11 provides functions and duties of the promoter. So for the first time, as I stated, that unorganized sector now was brought under this Act, and functions and duties of the promoters were specifically stated under section 11, which included the registration of the project with the authority and to provide the details. Now, apart from the details which I mentioned, it required quarterly update of the website and disclose the sale inventory or sale apartments, unsold inventory on the website. And it's also required to mention the registration number of the project on the advertisement prospectus. Now, having said that, the various responsibilities which were envisaged under section 11 is mainly to obtain completion certificate or occupation certificate from the relevant authority and to obtain or provide essential services, and then it was expected from him to execute the registered conveyance of deed of apartment, of plot or building, or as the case may be, in favor of association of allottees, and till actual handover of physical possession, pay all the outgoing charges in respect of the said project to the corporation and, as the case may be, to other government authorities. So for the first time, the liabilities and responsibilities of the promoter were put under section 11, which were expected, and failure of the promoter to complete with any of the liabilities and responsibilities which are mentioned in section 11 and other acts, which will come further, there is a mechanism provided to file complaint under section 31. But before we go to section 31, one of the more important section is section 13. Now, what is section 13? Section 13 mandated that if the builder accepts more than 10% of the entire cost of the apartment, plot or building, as the case may be, then the builder must register a return agreement for sale with such an allottee. Now, what this means is that the builder cannot accept more than 10% money of the entire consideration from the allottees without executing a registered agreement for sale. So friends, as we notice, and as I was mentioning, that specific performance of contract suits were taking their own sweet time if the promoter refuses to execute agreement for sale after having accepted money. So section 13 was introduced, which provided a speedy remedy that you can just file a complaint under section 31 with the authority saying that we have paid more than 10% of the money to the promoter and promoter is not executing registered agreement for sale. Then that order can be passed within 6 months, or that complaint can be disposed of within 6 months, directing the promoter to execute registered agreement for sale. Now, one of the reasons why I'm harping on registered agreement for sale under section 13 is the draft of registered agreement for sale is provided under the rules framed by respective states, which includes date of handing over possession of the apartment, which includes the entire consideration, and which also includes sanctioned layout plan and sanctioned building plan. Now, when I say so, the reason is section 14, which is the next section, which prohibits the promoter, once he has disclosed the project, once he has disclosed the layout plan and the building plan to the allottee, then he cannot change the same without the consent of 2/3 of the allottees in respect, if he intends to change the plan as provided under section 14. Otherwise, if there is no consent, then the promoter cannot do additions, alterations to the sanctioned plans, sanctioned layouts, and to the specifications which he has provided or mentioned in the agreement, so also which he has provided in the prospectus or advertising material, which is also required to be adhered to under section 12 of the Act. So section 14 of the Act, friends, provide that the promoter cannot change or alter the building plans or layouts without the consent. Similarly, we have seen recently that the entire project used to get transferred. Some promoters used to accept money from the flat purchasers and then hand over the project to some other builder, and used to say to the allottee that now they shouldn't follow it up with this promoter, but they should go to some other promoter, and so on and on. So to take care of this situation, section 15 was introduced. Section 15 clearly says that no project can be transferred without the written order of the authority. Another section, I think, friends, which is very relevant for the ongoing situation is section 18. So as I said that the Act clearly mandates now that the promoter must disclose the date on which he is going to hand over the possession. What happens if the possession is not given on the date which is promised? So section 18 takes care of this situation. Section 18 of the Act provides where the promoter fails to deliver the possession of the apartment as promised in the allotment letter or agreement as the case may be, then the promoter has to give interest. There are two options basically which are made available to the allottee flat purchaser. One, either the promoter can opt to exit from the project and tell the builder that, either the allottee can opt to exit from the project and say that, no, I don't want to stay with the project. I would like to exit from the project. Please pay my money, return my money along with the interest. Now, interest rate is defined. It is MCLR rate plus 2%. So the money lending rate ongoing plus 2% is the rate of interest, along with which the promoter has to return the entire money accepted by him from the allottee in case he fails to deliver possession to the allottee. The second aspect is he can choose to stay with the project. That all right, there is a delay in the project, fair enough, but still he will continue to stay with the project. In such circumstances, the promoter will have to serve him interest for the period from the date promised, that is the date of possession promised, to the date which is the date on which he will actually hand over possession. So that is section 18. It mandates two things. One, the allottee can exit from the project. And two, in case the allottee decides to stay with the project, then the promoter will have to service interest on the amount received by the promoter from the allottee till handing over of the actual possession of that apartment, plot or building as the case may be to the allottee. Now, that takes us to section 20. Now, before that, I must tell you, because I'm aware you all are preparing for the exam. See, in consumer court also, there is a provision where the flat purchaser can go to a consumer court claiming compensation for delayed possession and for not giving the services as are promised under the Consumer Act. The allottee can come to RERA also and say that there is a, look here, there is a violation of section 18 and therefore please service the interest. And then authority can give or rather direct interest also. The consumer can also file arbitration proceedings if there is a clause for arbitration for various other damages. So the question came before the Supreme Court as to which of these proceedings will stand in case the allottee chooses to fight against the promoter. And the Supreme Court said that Real Estate Regulation Act is in addition to the remedies available. So it is not that just because the consumer or allottee has invoked the RERA Act, he cannot approach any other forum or he cannot take any other steps to agitate his grievances. He can. RERA is in addition, as is provided under the Act. RERA is in addition to the other remedies which are available to the Act. In fact, there is a special provision which I will mention where it is specifically provided that where the cases in consumer court are pending and if the allottee so chooses, he can request to transfer that complaint from the consumer court to the authority for speedy disposal of the case. We will come to that shortly. So now section 18, the reason why I said is the main section of the entire act is, I think, section 13 and section 18. Section 13 mandates execution of agreement for sale, which discloses date of possession and everything which are to be provided or supplied by the promoter to the allottee. And section 18 deals with a situation in case the promoter fails to adhere to the terms and conditions of the agreement, then what is to be done is mentioned in section A, provided in section 18. Now, section 19 talks about the rights and duties of the allottees. Now, what are the duties and rights of the allottee? So, rights of the allottee is obvious, as stated here in above, as stated earlier. The rights of the allottees are to know the specifications and details of the plans, such as sanction plan, layout plans, and specifications of the project, the amenities which are to be provided by the project, the stage-wise schedule of completion of the project. So also, as I stated, one of the most and important thing, the date of possession. Date of possession to be provided. And lastly, but importantly, the stages of payment for the purchase of such an apartment. Now, having said that, section 20 talks about the establishment of the real estate regulatory authority. Section 21 states that the authority shall consist of chairperson and not less than 2 full-time members to be appointed by appropriate government. Section 22 provides for chairperson and other members and how the appointment is to be done. Now here, friends, there is one important aspect which I would like to point out here only. A question came before the Honorable Haryana Court that when the Act specifically mentioned that authority shall consist of chairperson and not less than 2 full-time members to be appointed by the government, whether the complaint can be heard by the chairperson or the members in their individual capacity, or every time all the 3 must sit together. While considering this question, the Supreme Court said that it is not necessary that all the 3 persons must sit together. In the rules, it can be provided who will hear the complaint and how the complaints will be disposed of. And accordingly, merely because the authority comprises of 3 persons doesn't mean every single complaint is required to be disposed of by all the members and the authority, and the rules can provide for disposal of such complaint. Now, as we discussed that establishment of authorities under section 20, the establishment of appellate tribunal is under section 43. Section 43 provides for establishment of appellate tribunal. Appellate tribunal shall consist of at least 1 judicial member and 1 administrative or a technical member. Now, Bombay High Court had again a question in case where it was specifically mentioned that every bench of the appellate tribunal shall consist of at least 1 judicial member and 1 administrative member, whether 1 single person can hear the appeals. And Bombay High Court has ruled that no, when section 43 subclause 3 specifically refers to the bench of appellate tribunal shall consist of at least 1 judicial member and 1 administrative member, then it has to be 1 judicial member and 1 administrative member, and single person cannot hear the complaints. Now, another aspect, one of the important aspect is section 43.5. Section 43.5 provides for a mandatory deposit. Mandatory deposit as in if there is a direction by the authority under section 18 to pay interest compensation, or if there is any penalty awarded, then it is mandatory for the promoter to first deposit the entire amount so received from the allottee, or entire amount received from the allottee or the compensation awarded, and without having deposited that money, the appeal cannot be entertained. Now again, constitutional validity of this section was challenged. Newtek's judgment we will refer to. Newtek, you can note Newtek's judgment, because that is one important judgment which I will in detail discuss with you. But the constitutional validity was challenged, and Supreme Court, while deciding the constitutional validity, noted that 43(5) condition of deposit of compensation or the entire money received from the allottee is only qua promoter. No such provision is made in case the allottee prefers an appeal. So Supreme Court said that this is rather a separate classification. Builder is a different class and flat purchasers are different class. So one particular class, that is builder who have already received the money, is required to deposit that money in the court, and therefore there is no violation of any constitutional rights, and it upheld the constitutionality of section 43(5) of the act that requires deposit of the entire money amount, as we discussed. Now, the act provides further for various provisions as to how the appeal is to be heard, the powers of authority and appellate tribunal, and the execution of the order. Now, Chapter 8 of the Act deals with punishment for non-registration and for violation or contravention of various provisions of the Act. So Section 59, Section 60 onwards, 59 onwards, basically, the Act provides for punishment and penalties for non-compliances under the provisions of this Act, which can, depending on the situation and facts and circumstances of the case, extend up to 10% of the project cost, which is to be disclosed by the promoter while registering the project. And it also provides for imprisonment in certain cases up to 3 years, where there is a failure to pay the compensation or cost, or where there is a contravention regarding various provisions of the Act, as I have already mentioned above. Now, that having said that, another important provision is establishment of adjudicating officer. Now, we saw under the Act, under Section 20, the Real Estate Regulatory Authority is established. Under Section 43, Appellate Tribunal is established. Now, under Section 72, adjudicating officer is established. For now, what are the duties of adjudicating officer? In case where the amount, or in case there is any unfair advantage taken by the promoter, or there is a loss caused to the allottee because of any defaults made by the promoter or the repetitive defaults of the promoter, then the adjudicating officer is appointed under Section 72 to do such, to take into consideration the loss which is caused to the allottee because of the conduct of the promoter, and such other factors which the authority may take into consideration, adjudicating officer may take into consideration, and to give such compensation under Section 72, which will serve the purpose and claims of the allottees. That is Section 72 of the Act. Now, there was a judgment of Supreme Court again in Nutex case, where the issue came is whether the Real Estate Regulatory Authority and adjudicating officers have one and the same powers, whether the complaints which are required to be decided under Section 31 of the Act are or can be disposed of by the adjudicating officer. And Supreme Court said no, adjudicating officers has powers which are specifically mentioned under Section 72, which are totally different than the duties or the authority of the regulatory authority established under Section 20. And therefore, Section 72, those cases which fall within the ambit of Section 72 shall be decided by the adjudicating officer, and the other cases shall be decided by the authority established under the Act. There is also a provision made that the dispute which is covered under this Act, Section 79 provides that no civil court shall have jurisdiction to decide any of the disputes which falls within the powers or the authority of the authority established under the Act, or adjudicating officer established under the Act, or appellate tribunal established under the Act. That is section 79 of the Act. Then another relevant section will be section 88. Section 88 of the Act provides that the provisions of this Act are in addition and not in derogation of the provisions of any other law for the time being in force. And then, friends, the last relevant section is section 92, which repeals Maharashtra Housing Regulation and Development Act 2012. So this is a cursory look of the Act. One important aspect I think we should discuss in detail, which remained, is section 31. Section 31 provides for the complaint to be filed. Now, who can file complaint? Any person who is aggrieved can file complaint to the authority, and association of persons also can file the complaint with the authority under section 31, which are to be disposed of in the manner provided under the Act. Second section, which I mentioned, I will quote subsequently, is section 71, which provides that any person whose complaint in respect of matters covered under section 12, 14, 18, 19 is pending before the Consumer Dispute Redressal Forum or Consumer Dispute Redressal Commission or the National Consumer Redressal Commission established under section 9 of Consumer Protection Act on or before commencement of this Act, then he may, with the permission of such forum or commission, as the case may be, withdraw the complaint pending before it and file an application before the adjudicating officer under this Act. So under section 72 of the Act. So these are the relevant sections, friends, which I think are important for you to note. Just to quickly revise section, I'll start quickly. Section 2 deals with the definition where allottee is defined, authority is defined. Then we saw section 3, which mandates registration of the project and not to sell, market, advertise without the registration of the project. Then we saw section 4, which mandates the promoter to disclose all the documents and upload them on the website. So also, which mandates the promoter to have a RERA bank account where he has to deposit money and operate as per the certificate issued. Section 7 and 8, as I discussed, gives powers to the authority to take the project from the promoter and hand it over to association of allottees or take such steps as may be necessary for completion of the project. Section 13 we discussed is in relation to the execution of agreement where promoter has taken money from the allottee more than 10%, then under section 13 he is required to execute registered agreement for sale. Section 18 is important section again, which we discussed, where the allottee can exit from the project or stay with the project and seek interest as in by way of compensation in addition to other remedies available to him. Section 31 is the complaint. Sorry, section 20 is the establishment of the authority. Section 31 is the complaint. Section 43 is establishment of appellate tribunal. Section 72 is establishment of adjudicating officer. Section 88, as I mentioned, is in it says that it is in addition and not derogation to any act. And then section 92, which repeals Maharashtra Housing Real Estate Regulation Act 2012. Now, friends, I said that one of the important judgments is the judgment of Newtek. Now, in paragraph number 25, section 18 and effect of section 18 read with section 19 were discussed by the Supreme Court, and Supreme Court held that legislature has consciously provided right of refund or demand as unconditional absolute right to the allottee. Therefore, what Supreme Court under section 25 in paragraph number 25 of new text said is irrespective of the reasons for delay in completion of the project. Earlier, builders used to argue that we can explain why there is a delay. But Supreme Court said irrespective of any reasons for delay, if it is not attributable to the allottee, then the promoter will have to service the interest. The Supreme Court in the judgment was also considering, now this is very interesting aspect. The Supreme Court in Nutex case was also considering that what is retrospective or retroactive act and the legal consequences tested on the anvil of Constitution of India. After reading various provisions of the Act, Supreme Court came to the conclusion that the Act is retroactive and not retrospective. Therefore, the Act applies to the project before the Act, but it is only active in respect of ongoing projects and not projects which are already completed. And therefore, Supreme Court answered that the Act is retroactive in nature and not retrospective, and therefore constitutionally valid. Then, in this very judgment, the another issue was whether section 81 of the Act authorizes the power, which I said that in Haryana there was a question raised, that whether a single person can decide the complaint or all the three persons are required to hear the cases. And Supreme Court, while deciding the issue, held that no, under the establishment of the authority, under rules, the powers can be delegated. And it is not necessary that every complaint needs to be decided by the authority, but it can be decided by the members, as well as it can be decided by the chairperson independently. So this is the one of the important case of the Supreme Court where constitutional validity qua the retrospective and activeness of the application of the Act was challenged, and the Supreme Court held that no, the Act is valid, the provisions are valid, and as I stated, it differentiated the powers of the authority and adjudicating officer under section 72, and it said that the Act is valid. Another judgment, friends, you should remember is Pioneer Urban. Now, in Pioneer Urban, the issue Pioneer Urban Land and Infrastructure Limited, the issue before the Supreme Court was in case of IBC. So we discussed Consumer Court and we discussed RERA. Now the third point was what is the effect of this issue of coming into force Insolvency and Bankruptcy Code 2016, and whether the promoter, if he goes under the IBC, what are the remedies available, and whether RERA will prevail over IBC. The Supreme Court in Pioneer held that no, in case there is a conflict between IBC and RERA, then IBC will prevail over RERA and the provisions of RERA will have to stay back. So these are the two important judgments of the Supreme Court on the issues regarding constitutional validity and on the issue of application of RERA. So I think we have taken a cursory look of the Act, which may help you. I wish you all the best for your preparations. And Hemangi Madam, you can take over from here now.
Thank you
If
very
you
much,
have
sir.
any questions, you can ask, but otherwise I think I am done with this. Yes, madam.
Anyone is having any questions?
Supreme Court case name I see in the chat box. I have said that Supreme Court case name is Newtech and then Pioneer Engineering. Ongoing and subsequent IBC is initiated, then all other proceedings will be stayed. So Neha has asked a question: if RERA proceedings are ongoing and IBC is initiated, then all other proceedings will be stayed. The answer is yes. As I stated, in view of Pioneer Engineering, where IBC is there, it will prevail over the RERA. What about Maharashtra Act 2012? So as I stated, this is very interesting situation. When Maharashtra Ownership Flats Act is in existence, Maharashtra Act 2012, because it fall within the concurrent list, was sent to for the assent of the president. The president never gave assent to that act, and instead RERA 2016 came. And I pointed out that the provision, there is a section 92 which provides for repeal of Maharashtra Act 2012. But as it never came into existence, there is no question of repeal. Anybody else? Every tribunal should have a law graduate. BCMG should do something about this. BCMG will do something about this. I think Udayji and Sangram is there. They will take care of your issues. Give the case citation. Okay, one second. Citation of Newtech. You can note down Newtech promoters. Newtech Promoters and Developers Private Limited versus State of Uttar Pradesh. It is 2021 Supreme Court. And what else is the question?
Sir, one query is regarding execution of order.
What is the query? So execution is provided under the Act. Now, if you want the procedural aspect, the procedure is this, that once the order is passed either by the authority or appellate tribunal, both the courts have powers to execute. The procedure is now to make an application online for execution of the order, which goes to the secretary of RERA, who in turn hears the applications and issues directions for recovery of compensation and monies under the Maharashtra Land Revenue Code. So ultimately he issues a warrant and direction to Tahsildar of that where the project is for recovery of the money. That is how the execution takes place in case of recovery of the money. In case of other aspects such as injunction and everything, again it has to be executed through the Maharashtra Land Revenue Code, and it will have to be implemented through the Tahsildars for injunctions. There are 4 new questions. 1 minute. RERA can directly affect real estate and any pending matter before consumer. As I stated, there is a section 71. So if the case is pending before the consumer court, there is a choice which is given. It doesn't affect. The choice is with the person, whether to continue with that consumer court proceedings or to withdraw it and go to the adjudicating authority under section 72. The choice is given to the allottee complainant before that. For real estate dispute, which is best authority for remedy, consumer commission or there is this is a debatable point, friends. I think I just saw Mr. Varunjikar was also there, who is president of Consumer Court Association. He will guide you more how fast and expeditious consumer courts are. As far as RERA is concerned, we are taking about 6 months to 8 months for disposal of the complaint. Now the time is gone on a higher side. It takes about 1 year. In which city Maharashtra RERA tribunal is working? So today the RERA tribunal we have established in, see there is one, first of all friends understand, there is only one authority established under the Act. The authority sits at BKC as well as at Churchgate, next to our Churchgate station, or those who know GLC Law College, near GLC Law College, the authority sits. In Pune, they used to sit initially, but now I am told there is no member who is taking up hearing, and all the matters are being heard by the authority. Now, one of the important aspects as a practicing lawyers, all of you should know, is that the authority is online. So it makes no difference where he sits. All the complaints starting from filing to disposal are done online, and therefore it is irrelevant where he sits. If builder did not disclose the parking numbers, mechanical type of car parking. Friends, this issue is no more res integra. Builder cannot sell car parking. He has to disclose. If he has not disclosed, Then there is a complaint under section 31. Matters are not getting listed. Yes, so Siddharth, that is a fact. Matters are now getting delayed because the pendency has gone high. But eventually, I think this issue is getting sorted out with appointment of additional members. We will decide. What is the hierarchy of adjudicating and appellate authority in RERA? So there is no, please understand, there is no hierarchy. The authority is established under section 40 and the appeals are heard by the appellate tribunal established under section 43. The appellate tribunal is also at Kalagoda opposite our Bombay High Court. What matters can be filed before RERA as well as before Consumer Court. So where there is defect in services, as you friends are aware that the case will go to the Consumer Court. All the issues or problems which can be handled by RERA can be handled by Consumer Court also. As I stated, the choice is there.
Sir, I think there are repeated questions.
Yeah, now I will. I think I have answered all the questions. Thank you, Sangramji. Thank you for inviting me here and giving me this opportunity of having conversation with all of you. Thank you very much.
Thank you, sir. On behalf of Bar Council of Maharashtra and Goa, I extend my sincere thanks to sir for giving your valuable time and throwing flash on the important provisions of RERA Act, along with what is the necessity of establishment of this act or enactment of this act in relation or in relevance to the Consumer Act. Thank you so much, sir. And thank you participants also for making this session live by raising your queries before, sir. One more important announcement. Tomorrow also we are having another session. Do join us sharp at 6 p.m. Thank you, sir.